TWPM English shorthand dictation. Be ready. Start. Para. Submitted that admittedly at the time of accident the deceased was working as animal medical officer under the state government. The tribunal the tribunal assessed the age of the deceased as 48 years thus in view of the judgment of the Honorable Supreme Court in Sarla Verma Supra, it is imperative for the tribunal to make addition of 30% in the income of the deceased because the deceased was in the age group of 40 to 50 years. It is further submitted that the learned tribunal had wrongly deducted rupees 16,420 from the income of the deceased, with the claimant number 1 is getting from the state government towards family pension. It is submitted that in view of the various judgment of Honorable Supreme Court in and of this court, family pension received by the widow of the deceased is not liable to be deducted from the income of the deceased. Therefore, it is submitted that the entire assessment of compensation made by the tribunal is illegal and against the law laid down by the Honorable Supreme Court. Para. On the other hand, Shri G.K. Srivastava, learned counsel appearing for Assonance, the insurance company submitted that the tribunal had assessed the compensation in accordance with law. It is submitted that one-third amount of the income was deducted by the tribunal in view of the second schedule of the Motor Vehicles Act. It is further submitted that the learned tribunal refused to give benefit of future prospect because the claimants had not adduced any evidence to show that in future income of the deceased will be enhanced. The tribunal had further stated that there may be chance that the claimant number 1 will get compassionate amount due to death of deceased. Accordingly, it is submitted that the aforesaid finding of learned tribunal does not require any interference. Para. It is settled principle of law that the evidence of interested or related witnesses should be considered with caution and until and unless it is found to be trustworthy, the conviction of accused on the basis of evidence of related or interested witnesses is not justified in view of the discussions made above and considering the unnatural conduct of PW1 and PW2. I am of the considered view that they are not proved to be eyewitnesses of the incident of enticing away victim by accused appellant in presence of co-accused persons or otherwise, and their testimony is neither reliable nor trustworthy. Para. In the present case, the only eyewitness of the incident, PW1 and PW2, are admittedly closely related witnesses, and their conduct has been found unnatural in not disclosing and not helping the first informant. The conduct of father of the victim is not lodging the FIR and not appearing before the trial court for stating on oath that his daughter is missing and has been enticed away by the accused appellant with the help of other co-accused or otherwise, and the conduct of PW3 first informant, who himself is a law graduate and is also alleged to be an advocate, in not mentioning the names of alleged eye witnesses in the FIR and lodging of FIR with inordinate delay of 4 days at midnight without any whisper about the love affair, if any, between the victim and the accused appellant, and further the undisputed disability of accused appellant makes the entire prosecution story highly improbable and doubtful, and gives strength to the arguments that the father of victim and his family members, including first informant on account of property dispute, have falsely implicated the accused appellant and his family members due to suspicion in view. Full stop.